This short guidance video is one of a series produced by JISC Legal in supporting staff who are directly involved with business and community engagement or BCE activities within their institution. JISC Legal are one of several services that are part of the JISC BCE programme. This video has a general introduction to confidential information and the potential impact of freedom of information legislation on disclosure of external information held by an institution. Elaine McKinney will then provide you with guidance on confidentiality and how this may be addressed by institutions through specific agreement clauses. Finally, we will conclude with a summary of recommendations. There will be situations when work being done within the BCE partnership will be treated as confidential. In this video, we will focus on confidential information which is likely to be a valuable asset. It's crucial to any BCE project that all parties are aware of the freedom of information implications and the exemptions that may apply. An institution as a public body is subject to freedom of information, and if they hold the information regardless of who owns the rights to it, then they may have to hand it over. Therefore, the institution's FOI policy should be shared with all parties involved in the project. The qualified exemption relating to confidential information may be of particular interest here. For further information on FOI, please refer to Video 1, Data Sharing for Research. Confidential information can prove especially valuable for institutions, but without IPR protection, such as copyright, a database right, or patent, disclosure of confidential information is a real risk. And this can take many forms: face-to-face, on the phone, by email, and so on. Elaine McKinney, a contracts manager who is part of the research and innovation team at the University of Strathclyde, offers us a practical view of confidentiality and highlights some of the risks and practical situations where disclosure may take place.
I guess the key thing for me about confidentiality is just to make sure that you're really aware of it all the time and that members of your team are really aware of it, and that you're taking lots of practical steps to make sure that confidential information is kept confidential. So that can be things as simple as making sure that things are password protected and only certain people have access to things. Because at the end of the day, if you disclose confidential information when you really shouldn't, it's going to be fatal to any patent filing that you're trying to do later on. So it's really important to try and get your technology transfer or research and innovation office involved at the very, very beginning of any kind of contact with a business or other higher education institution. It's so easy, I think, to disclose information without meaning to. It's very easy to be invited along to participate in a poster session or to speak at a conference. It's sometimes difficult to know when you get an initial contact from a business whether what they're asking you to do is going to go somewhere or nowhere. And so things can start to progress at a pace without you realising that you're starting to hand over confidential information because you're basically providing ad hoc consultancy to a company without having documentation in place. So at that stage, and really early on in the process, you should be thinking about getting a confidentiality agreement in place. I've also come across situations where a company says it's fine, we've done business with the university before, we've got a confidentiality agreement in place, and that can be quite reassuring for an academic, and they kind of feel there's no need to check that out, or it can be embarrassing to say, well, can you give me a copy of that, can I have a look at it? And quite often you find that the business was done years before and the confidentiality agreement has either expired or it just doesn't apply to the project that's being done at this point in time. So it's always worth getting a new one in place and making sure that it covers not just the business's confidential information but also the university's confidential information as well. Quite recently we've had quite a few academics who've been personally invited by companies to come and speak at science fairs or science days, and very often tacked onto that is maybe a roundtable event or a brainstorming or an exchange of ideas. And again, that's something that's very flattering to be invited along to do that kind of thing, but there has to be a confidentiality agreement in place before you set off travelling down to these kind of things. Quite often we find our academics haven't really thought about it in advance, and they actually get to something like this and the company says, can you just sign this bit of paper? And that then leaves the university in the position where an individual academic has signed something which perhaps isn't the best way forward. The main thing is to get your technology transfer office or your equivalent office involved really early on in the process so that a confidentiality agreement can be put in place, or if it's a different type of agreement, a research agreement, a consultancy agreement, that the confidentiality clauses can be looked at. It's a bit more of a specialised area now because of freedom of information legislation. It's not the case anymore that all information can just be designated as confidential information. It really has to be thought about and confidential information identified as confidential information. And so technology transfer office, it's really bread and butter work putting these kind of agreements in place. It doesn't take a long time, it's not going to hold up whatever transaction you're wanting to do. Also tied into the area of confidentiality, and something that could cut across it if it's not specifically dealt with in an agreement, is the clause dealing with publication rights. Obviously that's a really important one for a university to have in there. We want our academics to be able to publish papers, we want students to be able to complete a thesis and get that out into the wide world, and obviously that can conflict sometimes with a company's idea of keeping information confidential and making sure that commercialisation plans don't come to grief because of these publication clauses. So it's definitely something that should be thought about again early on when the agreement's being drafted, to make sure that everybody's comfortable. And the way that can sometimes be dealt with is that the company having an ability to stop the university from publishing certain things if they contain confidential information, or to delay that publication to allow perhaps the company to file a patent or to take some other measures to protect intellectual property. It's very important to think about a publication clause when you're actually drafting the agreement, and the way that it can sometimes be done is to find a balance between the university's wish to publish things and the company's wish to protect intellectual property rights. So either what can happen is that the company could prevent the university from publishing something only if it contains company confidential information, or could prevent the university from publishing something just for a time-limited period so that the company has time to file a patent or protect the intellectual property in some other way.
Lord Gough, in the famous spy catcher case, summarised the duty of confidence as follows. A duty of confidence arises when confidential information comes to the knowledge of a person in circumstances where he has notice or is held to have agreed that the information is confidential, with the effect that it would be just in all the circumstances that he should be precluded from disclosing the information to others. To avoid any uncertainty, confidential agreements or a letter would place the individuals under a contractual obligation not to disclose. So, when dealing with confidential information, the following points should be noted. Consult with your technology transfer office for advice and guidance on commercialisation and exploitation of IPR. Consider implementing a confidentiality agreement and share that with the relevant parties. Decide what the confidential information is and clearly mark that. Only permit secure access to information for authorised persons as listed in the agreement. Disclose only when absolutely necessary, and discuss your approach early on in the process with staff. If you require further information on this area, please have a look at our website under the theme BCE.